Welcome to the law offices of Chris M. Ingram's Immigration News Podcast. This week we're doing a special on President Trump laying siege to birthright citizenship, which is protected under the 14th Amendment of the Constitution, and also taking away U.S. citizenship for outspoken critics of his policies. We also really want to discuss the potential unintended consequences this policy will have on all documented workers on valid visas. Find out how their children could find themselves in, well, real difficulties if they are born in the U.S. It's not looking good. We would like to thank the staff at the law offices of Chris M. Ingram for their hard work in researching and preparing the legal research. However, if you have any concerns about the issues raised in this special podcast, please feel free to visit their website at www.breakthroughUSA.com, where you can schedule a free consultation. Today we're doing a deep dive into an issue that is fundamentally challenging the very definition of American identity and citizenship. It's a complex topic, definitely, with profound implications for millions of people, and our legal team has provided some really incredible legal research to help us unpack it.
Yeah, absolutely. And what's fascinating here, I think, is how deeply rooted the concept of citizenship is in America's identity, and how these recent policy shifts are creating such a potent sense of fear and uncertainty across a really wide array of communities. We'll be looking closely at the historical foundations, the legal battles currently unfolding in the courts, and maybe most importantly, the real-world human impact of these sweeping changes. It's a critical moment, really, where these foundational principles are being tested, and understanding the nuances is absolutely key to grasping the full scope of what's truly at stake for individuals, for families, and, well, for the nation as a whole.
Okay, let's unpack this then. Our legal team's research highlights that America is standing at a pivotal crossroads regarding its citizenship policies. When we say citizenship is under siege, what exactly are we talking about? It sounds like much more than just a, simple policy tweak.
Oh, indeed. It's far more profound than a mere tweak. We're observing really a two-pronged challenge that directly assaults established norms and legal precedents. So firstly, there's this audacious and frankly unprecedented push to curb birthright citizenship. And this isn't just about controlling immigration, you see. It's about fundamentally altering who automatically becomes a U.S. citizen just by being born on American soil, which is a concept that's been pretty foundational to our nation's identity for, well, over a century now. The proposal seeks to redefine a right that's been largely undisputed since the 14th Amendment was ratified. And then secondly, and equally alarming, is an expansion of denaturalization efforts. Now, that's the process of taking away citizenship from people who've already gone through the often really arduous and lengthy process of becoming naturally citizens. So both of these policies, if they're fully implemented as proposed, they threaten to unravel the promises of equality, due process, and belonging that are embedded within the 14th Amendment, which has long served as a bedrock of American identity and inclusion. They represent a fundamental shift in how citizenship is acquired and, crucially, how securely it's held.
And when we talk about these policies, what are the immediate sort of tangible concerns that individuals and families should be aware of, especially those caught in the crosshairs of these potential changes? It sounds like there could be some incredibly dire personal consequences at play here.
Oh, absolutely. For children born on U.S. soil, particularly those whose parents might be undocumented, or even, and this is key, on certain types of temporary valid visas, there's the chilling prospect of statelessness. Just imagine being trapped in a legal void, a kind of existential limbo where no nation officially recognizes you as a citizen, and therefore no nation claims you. This isn't just an abstract legal concept, right? It means a life devoid of the fundamental legal recognition that underpins almost every aspect of modern existence. I mean, getting a passport, a driver's license, voting, accessing certain jobs, federal financial aid for education, even just being counted in national statistics. It's a fundamental erasure of identity and opportunity. It's huge. And then for naturalized citizens, the fear of retribution for speaking out against policies, or maybe for past minor discrepancies in their application, that's becoming very real. Their hard-earned status, often the culmination of years of diligent effort, patience, adherence to complex rules, it could be put at risk. This creates a deeply unsettling environment where exercising free speech, a core American value, a constitutional right, could potentially lead to the loss of their citizenship. It's a very, very difficult predicament to be in, fostering a climate of profound insecurity for millions who thought their status was secure.
Wow, okay. And our team's legal research, it includes an urgent call to action from attorney Chris M. Ingram directly addressing these looming concerns. What does he advise people to do right now? in light of all this?
Chris emphasizes urgency. His advice is incredibly direct, pragmatic, and really centered on securing one's status as quickly as possible. He states, and I'm quoting here, "For those work visa holders who are eligible to apply for a green card, do so without delay." Quote, "And for green card holders who are now eligible for U.S. citizenship, waste no time in applying. If you need help, visit our website at www.breakthroughUSA.com for a free assessment." So this isn't just, a suggestion. It really underscores the gravity of the situation. It highlights the immediate proactive need for those eligible to secure their status while the pathways remain clear. The landscape of immigration law is shifting rapidly, and his message is crystal clear. If you have a pathway to a more secure status, green card, or citizenship, pursue it now, because delays could lead to really unforeseen difficulties down the road.
That makes sense. To truly understand where we are today and why these current proposals about citizenship are so significant, so contentious, we probably need to glance back a bit at how American citizenship itself has evolved over time. What does our legal team's research tell us about the very early days of naturalization? Was it always this complex or this inclusive?
Oh, not at all. Not even close. The path to becoming an American citizen began with the Naturalization Act of 1790, and it was strikingly restrictive by today's standards. I mean, really limited. This act limited eligibility initially to free white persons. That's the exact wording. And it required just 2 years of residency in the United States. It's a really stark reminder of how race was absolutely central to who could even be considered an American citizen from the very beginning of the nation. This wasn't about universal inclusion. It was a deliberate legislative act to sort of curate the new nation's demographic makeup, reflecting the racial hierarchies of the time. The whole concept of who could belong was tied to race.
Right. So definitely not the open melting pot ideal we sometimes think of. What came next? Did it become more formalized?
Well, in 1795, just 5 years later, Congress extended the residency requirement to 5 years, and they added a formal declaration of intent to become a citizen. Now, this wasn't really a move towards greater inclusion, but more an early attempt to formalize the process, make it less ad hoc. It required a more deliberate public commitment from applicants. You had to publicly declare you wanted to join the U.S. But, and this is crucial, despite this procedural change, the racial restriction to free white persons remained firmly in place. That core identity of a citizen legally was still tied to race. That persisted for a very long time.
Okay, so when do we finally start seeing a real shift towards a more inclusive definition, moving beyond that free white person standard?
The first really monumental shift came with the 1870 Act. This was a direct result of the Civil War, the amendments, the Reconstruction era. This act was significant because it finally included African Americans in the naturalization process. It acknowledged their newfound freedom and citizenship under the 14th Amendment, a huge step. It reflected the nation's efforts to redefine citizenship after slavery. But even with this progress, racial barriers stubbornly persisted for other groups. Notably, individuals of Asian descent faced continued, often explicit exclusion. Think about the Chinese Exclusion Act of 1882. That lasted for decades. It wasn't until the Comprehensive Immigration and Nationality Act, the INA of 1952, that all racial exclusions were finally and systematically removed from the naturalization law. That 1952 Act really set the modern standards we largely follow today, fundamentally moving towards eligibility based on legal criteria, not race.
And what are those modern standards, the ones our legal team highlights from the INA? For someone listening, maybe thinking about this path, what does it actually take now? What's the process like?
Right. The INA established key criteria that are still applied today. The foundation is generally 5 years of lawful permanent residency, having a green card for 5 years. That period's reduced to 3 years for spouses of U.S. citizens, recognizing the family connection. Beyond residency, applicants have to demonstrate good moral character. That involves a thorough review of their record, conduct, making sure they uphold community standards, essentially. They also need to show proficiency in English, basic reading, writing, speaking. And finally, applicants have to pass a civics test, proving they have a fundamental understanding of U.S. history and government. It's a pretty comprehensive process designed to ensure new citizens are integrated, understand their responsibilities, and can participate fully.
Okay, and given how involved that process sounds, how many people are actually going through it successfully each year? It must be a significant number.
It really is. Our attorneys tell us that in 2023 alone, a remarkable 878,500 immigrants successfully became citizens through this established process. That number gives you really important context for the sheer scale of naturalization in the U.S. It shows that even with a complex process, hundreds of thousands of people each year are making that transition, becoming full participants in American society. It really underscores the enduring appeal of the U.S. and the success of this pathway for so many.
Okay, now let's shift gears to something much more unsettling, potentially devastating: denaturalization. What exactly is it, and what does our legal team's research show about its history and, crucially, recent changes? This sounds like it could undo everything we just talked about.
USCIS is cracking down on visa fraud, and even approved cases are being revoked.
Why was my visa denied? USCIS revoked my approval. At the law offices of Chris Ingram, we handle every detail with care. Every form, every fact, every time.
So join us for a free consultation. We do things the right way. Let us take care of you.
Denaturalization is precisely that, is the revocation, the taking away of citizenship from people who've already become naturalized citizens. And yes, it is, as you say, an incredibly devastating measure. It essentially undoes years of effort, uproots a life built on U.S. citizenship. Historically, it happens when citizenship was obtained through fraud, misrepresentation, or illegal means, like concealing a serious criminal history, lying about who you are, misrepresenting key facts on your application. Traditionally, it's been a truly rare action, reserved for the most severe offenders where there was clear evidence of profound deception.
Can you give us some examples of who it targeted historically? It sounds like it was for very specific, serious cases, right?
Yeah.
Not just minor errors.
Absolutely. The research from our attorneys shows it was largely targeted at individuals involved in the most egregious offenses, often related to national security or major historical wrongs. For instance, it targeted former Nazis who hid their war crimes during World War II when they came here and sought citizenship. Similarly, it was applied to terrorists who misrepresented affiliations or intentions to get citizenship. And to put its rarity in perspective, between 1979 and 2011, the DOJ's Office of Special Investigations, which focused on these cases, they denaturalized only 107 individuals specifically for World War II-related crimes over that entire period. That really underscores how narrowly and gravely this power was historically used, reserved for cases of fundamental deceit.
Okay, so definitely not common, reserved for severe fraud. What are the specific legal grounds for denaturalization our team found? What actually triggers it?
There are primarily 4 very specific legal grounds, and each needs a high level of proof. First is illegal procurement. This means the person actually failed to meet the basic eligibility requirements when they applied. Like, they falsely claimed they met the residency requirement, or maybe they weren't lawfully admitted in the first place. Second is concealment or misrepresentation. This is about hiding or lying about material facts during the process. Things like hiding a serious criminal conviction, a felony, or past ties to a terrorist group that would have disqualified them. The third ground is post-naturalization conduct, specifically engaging in terrorism, espionage, or advocating for overthrowing the U.S. government within 10 years of becoming a citizen. But there's a critical point here. The government has to prove the intent to do that existed at the time they applied for citizenship, not just that they do it later. And finally, there's military dishonor. For those naturalized through military service, a dishonorable discharge within 5 years could potentially lead to denaturalization if the conduct relates to a lack of allegiance. Each ground really focuses on a deliberate undermining of the naturalization process itself.
That sounds like a serious legal process, not just an administrative decision. How does it actually work? What's the standard of proof?
You're absolutely right. It's rigorous, constitutionally protected. Denaturalization requires a federal court action. An agency can't just decide to do it. The government has to file a lawsuit in federal court. For civil denaturalization cases, the standard of evidence is clear, convincing, and unequivocal evidence. That's a much higher bar than the usual preponderance of evidence in civil suits, though lower than beyond a reasonable doubt in criminal cases. For the much rarer criminal denaturalization cases, it is the beyond a reasonable doubt standard, like any criminal prosecution, and it must happen within 10 years of naturalization. This strong legal framework is designed to protect citizens from arbitrary removal of their status, ensuring due process.
And there was a key Supreme Court ruling recently, wasn't there? Jack. That clarified what material misrepresentation means. It means crucial.
Yes. The 2017 Jack v. United States ruling was absolutely crucial. It provided much-needed clarity on that materiality standard. The Supreme Court unanimously held that any misrepresentation made during naturalization must be material to trigger denaturalization, meaning it has to be a falsehood that actually impacted the eligibility decision, capable of affecting the outcome. So if someone, say, accidentally put the wrong middle initial or made a minor, insignificant error, that likely wouldn't be material. But if they had a serious felony conviction or undisclosed ties to terrorism, that would have absolutely disqualified them. That would be material. This ruling aimed to prevent denaturalization for trivial errors, focusing instead on genuine fraud that undermines the whole process, a significant safeguard.
Okay, here's where it gets really interesting, though. Our legal research indicates that during Trump's first term, efforts to pursue denaturalization seemed to intensify, maybe broaden beyond those narrow historical cases. What did that look like? How did it signal a shift?
Well, the Department of Justice, the DOJ, definitely launched new initiatives that signaled a broader, more aggressive focus. In 2020, they created a specific section within the DOJ explicitly targeting terrorists and fraudsters. That signaled increased resources, a dedicated team. While ostensibly about national security, it raised concerns about potentially broader application. There was also Operation Janus, launched earlier, a multi-agency effort. By 2018, it had identified 858 cases of alleged fraud. These operations aimed to re-examine older naturalization cases, especially those that might have slipped through earlier checks due to, say, data gaps or less robust digital records years ago. The motivation appeared to be more comprehensive review, not just targeting the most egregious new cases.
Are there any prominent cases from that time that illustrate how these efforts were applied? Maybe how they were seen by the public?
Yes. Attorney Chris Ingram's research highlights two notable ones that got a lot of attention and show the application of these grounds. In 2017, Resmea Day, a Palestinian-American activist, was denaturalized for concealing a 1970 terrorism conviction in Israel. Her case was very contentious. Supporters argued it was politically motivated. The government maintained it was about undisclosed material facts. Another significant one was Parvez Mansour Khan in 2018. He was denaturalized for hiding ties to a terrorist organization during his naturalization. These cases, while distinct, demonstrate the focus on individuals where serious, undisclosed information, especially related to national security or past conduct, was later revealed. They showcase the government's willingness to pursue denaturalization with, well, renewed vigor.
This brings up a really important question, especially for you listening. What are the broader concerns around this expansion of denaturalization, beyond those clear-cut cases? How might it affect someone just navigating the system, maybe a naturalized citizen who speaks out?
Well, that 2020 DOJ initiative, expanding denaturalization to include broader categories like national security threats and fraud, it definitely raised significant fears. Among immigrant communities, civil liberties advocates. Critically, our legal team points out concerns that it could potentially be used, or at least perceived as being used, to target critics of the administration, particularly minorities maybe, for dissent. Now, while it's true that a single minor paperwork error shouldn't trigger denaturalization on its own, based on Jack, the broadened focus could prompt intense scrutiny of applications, especially for individuals who are outspoken or seen as political adversaries. The concern is that minor discrepancies, maybe things not fully disclosed but perhaps not strictly material, could become pretexts for investigations, leading to long legal battles, immense stress. And this has a profound chilling effect on free speech for naturalized citizens. If you're a naturalized citizen and you fear that criticizing the government could lead to an investigation digging up some technicality from your past, you might feel pressure to just stay quiet. It shifts the perception of naturalized citizenship from secure and irrevocable to something that feels, well, conditional, precarious, dependent on remaining silent or aligned.
Okay, let's pivot now to birthright citizenship. This feels like the absolute bedrock for so many people what it means to be American. Our team's research points straight to the 14th Amendment as the foundation here. What does it say that makes this so fundamental?
The 14th Amendment, yes. Ratified in 1868, right after the Civil War. It's the bedrock. It clearly states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Now, this short but incredibly powerful clause was primarily designed to ensure that formerly enslaved people were unequivocally recognized as citizens, to prevent them from being denied rights. But its language is intentionally broad. All persons born here, regardless of their parent status. And that broad language has been interpreted for over 150 years to mean that birth on U.S. soil confers citizenship, the principle of jus soli, right, of the soil.
And that wasn't just left to the amendment's wording, right?
Mm-hmm.
It was cemented by a landmark Supreme Court case. Can you walk us through that one?
Exactly. That enduring principle was decisively affirmed by the Supreme Court in the 1898 case, United States v. Wong Kim Ark. Super significant case. Wong Kim Ark was born in San Francisco in 1873. His parents were Chinese immigrants, legally residing here, but ineligible for naturalization themselves due to discriminatory laws like the Chinese Exclusion Act. When Wong Kim Ark returned to the U.S. after a trip to China, they denied him re-entry, saying he wasn't a citizen. The case went all the way to the Supreme Court. And the court, in a clear 6-2 decision, explicitly affirmed that children born in the U.S. to non-citizen parents are citizens under the 14th Amendment's subject to the jurisdiction thereof clause. That ruling firmly established dissent as the law of the land, ensuring nearly everyone born on U.S. soil is a citizen, regardless of their parent status. It's been the standard for well over a century.
There are just too many visas out there, and I don't know which one is right for us. We need to get the right advice.
Communication is everything, and I just need someone who will listen and guide me to the right visa type, and not make promises that they can't deliver.
There are so many documents. I need someone to walk me through each one. I can't afford to make any mistakes.
If I can just find a lawyer who understands my potential, I know America will be an excellent opportunity for me and my family.
Welcome to the law offices of Chris M. Ingram. And we are your immigration lawyers, and we will be with you every step of the way in your immigration journey.
At the law office of Chris M. Ingram, you get a free consultation so we can understand your needs.
We don't make promises we can't keep. Our success rate speaks for itself.
Join us and access your step-by-step video guides that answer every visa question.
Their platform is amazing. There are videos that instruct you on everything you have to do. It meant we were in control and we could do it in our own time.
They couldn't have been more helpful. They answered every question that I had, and it was easy to see they were the lawyers for me.
I couldn't believe it with my busy schedule. They always had time to talk to me and put me at ease. That's what I like about them.
So go on our website and get your free consultation now, and your new life is about to begin.
Ask me.
We did it! We did it!
We did it!
Oh my God, I got my visa! Yes, I did it!
Okay, so with such clear constitutional backing, a long-standing Supreme Court precedent, how has President Trump proposed to change this? It seems like a huge legal mountain to climb.
Well, despite that strong precedent, President Trump, back in October 2018, formally proposed an executive order to end birthright citizenship specifically for children of undocumented immigrants. His stated reason was to curb what he called birth tourism, people coming just to give birth, and also to reduce illegal immigration by removing the perceived incentive of citizenship for their kids. This executive order was then publicly reintroduced, re-upped as a policy goal in 2025, showing a continued commitment despite the legal hurdles. The proposal directly challenges over a century of law and interpretation, attempting to bypass the constitutional amendment process through executive action.
Who would be specifically impacted by this order, according to our attorneys? It sounds like it reaches beyond just undocumented families or birth tourists.
Oh, absolutely. It targets several significant groups, much broader than the birth tourism narrative suggests. Firstly, yes, children of undocumented parents. Our attorneys estimate this affects around 200,000 births annually and impacts about 4.4 million U.S.-born children already living in mixed-status households, kids who've known no other country. Secondly, and this is a crucial point often missed, it would hit children of temporary visa holders. We're talking about maybe 150,000 births each year to parents who are here legally on various non-immigrant visas. F1 students, H-1B skilled workers, B-2 tourists who might overstay, L-1, O-1, E-2, TN visas. These are people lawfully present, contributing to the economy, studying here. Denying their U.S.-born kids citizenship would create the subclass where parents followed the rules, yet their children are stateless. And finally, yes, it also targets children of birth tourists. Roughly 33,000 annual births attributed to women, mostly on B-2 visas, often from China or Russia, who do come specifically to give birth. While this group gets attention, it's a smaller fraction of the total impacted, so the scope is incredibly broad, affecting millions of existing kids and hundreds of thousands of future births, both undocumented and legally present families.
Wow. Okay, if it's been proposed since 2018, why hasn't it been fully implemented across the country?
Yeah.
Given the administration's commitment.
Right. This is exactly where the legal battles, the judicial review process, really kicked in. The 2018 proposal faced immediate, widespread lawsuits. A coalition of 22 states, the ACLU, various immigrant rights groups. Their core argument was always that the executive order violates the 14th Amendment and the Wong Kim Ark precedent, that a president can't just change the Constitution with an order. And as a direct result, federal district courts in Maryland, Massachusetts, and Washington quickly issued nationwide injunctions. These injunctions essentially blocked any enforcement of the order across the entire country, holding the policy in legal limbo for years while the challenges played out.
So those injunctions stopped it. But something big changed recently with the Supreme Court weighing in on those injunctions, right? That sounds critical.
Yes, this is where it gets really interesting. The legal landscape shifted dramatically. On June 27, 2025, the Supreme Court, in a major 6-3 decision in Trump v. Sesa, Inc., fundamentally limited the scope of those nationwide injunctions. The court ruled that these injunctions would only apply to the actual plaintiffs who brought the lawsuits. So only the specific states, organizations, and individuals who sued would get direct relief. Now, this was a critical procedural ruling, not a ruling on the ultimate constitutionality of birthright citizenship itself. That's key. What this means for implementation is that the Supreme Court's decision now allows partial enforcement of the executive order. After a 30-day pause, it can now potentially be implemented in the 28 states that were not part of the original lawsuits. Crucially, though, and this is vital for you, the listener, to understand, the Supreme Court did not rule on the constitutionality of the order itself. They deliberately left that fundamental question unresolved as of July 2025. The core legal challenge to ending birthright citizenship is still very much ongoing. An appeal on the merits of its constitutionality is scheduled for August 1st, 2025. So while it was a procedural win for the administration, it was not a constitutional green light for the policy itself.
That distinction is incredibly important. So what was the reasoning behind the majority's decision to limit the injunctions like that? Why the narrow approach?
Justice Amy Coney Barrett, writing for the majority, emphasized a specific view of judicial power. She argued that federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. Her main point was that a court's power to issue an injunction is primarily to give specific relief to the specific plaintiffs in that case, not to halt federal policies nationwide in all situations. So, she stressed, injunctions must be no broader than necessary to provide that direct relief. Essentially, the majority was reining in the use of those sweeping nationwide injunctions that had blocked policies everywhere, suggesting broader relief should be sought through other ways, like class action lawsuits or a final ruling on the policy's merits later. It's a significant move, reflecting a broader conservative judicial philosophy about the proper scope of judicial power versus executive power.
Did any other justices on the majority side add anything?
Yes, Justice Brett Kavanaugh wrote a concurring opinion. He reiterated a point about alternative paths for broad relief. He noted that while nationwide injunctions were curtailed, plaintiffs could still seek class action lawsuits. Which is significant because a successful class action, by definition, would represent and potentially cover all affected individuals nationwide. It could achieve a similar outcome to a nationwide injunction, just through a different legal mechanism that the majority seemingly finds more appropriate. His concurrence suggests the fight for universal relief isn't over, but the procedural route has changed.
But there was strong dissent, too, right? Showing a real split on the court about what this ruling means. What did the minority justices say?
Oh, very strong dissent. Justice Sonia Sotomayor, joined by Justices Kagan and Ketanji Brown Jackson, delivered a powerful, sharply worded dissent. She flat out called the ruling a travesty for the rule of law that renders constitutional guarantees meaningful in name only for any individuals who are not parties to a lawsuit. She argued passionately that the executive order's patent unlawfulness, its clear violation of precedent like Wong Kim Ark, should have warranted the broader nationwide injunction. Sotomayor warned starkly of chaos for the families of all affected children who risk statelessness due to this fragmented patchwork application of law. She strongly urged lower courts to act swiftly on class action requests to block the order nationwide, showing profound concern for the immediate human consequences. Her dissent painted a picture of a court, in her view, failing to uphold consistent constitutional rights across the country.
And Justice Ketanji Brown Jackson also wrote separately.
Yes, in her separate, equally powerful dissent, Justice Jackson called the decision an existential threat to the rule of law. She accused the majority of effectively granting the executive branch unchecked arbitrary power by limiting the court's ability to issue broad injunctions against policies she saw as clearly unconstitutional. Her dissent emphasized the dangerous precedent this sets, where executive actions can be partly implemented without full, immediate constitutional review everywhere. She argued it weakens checks and balances, allowing the executive to act without adequate, timely judicial oversight, creating a perilous environment for rights and legal certainty.
So what's been the immediate fallout from this Supreme Court decision? It sounds like it's thrown everything into a state of flux, real uncertainty across the country.
You're exactly right. The fallout was immediate and created a deeply confusing, potentially devastating situation. Our legal team tells us immigrant rights groups like HASA acted within hours of the ruling. They immediately filed new class action lawsuits, aiming specifically for nationwide relief for all children born after February 19, 2025, the order's effective date. This situation has created this profoundly confusing, potentially devastating patchwork of citizenship rights. Imagine, a child born in a state covered by the remaining injunctions might still be a citizen, but a child born just across the state line in a state not part of the original suit could suddenly be deemed stateless. It creates this legal and moral nightmare where citizenship depends on geographical luck and the uncertain outcome of ongoing litigation state by state. It really underscores why it's so critical to be informed and, if you or someone you know might be affected, to seek legal guidance right away. The ground is literally shifting.
Okay, if this policy were fully implemented, our attorneys say it would create a stateless generation. That phrase carries enormous weight. What does that actually mean for families and kids practically day-to-day here in the U.S.?
It's a profound humanitarian concern, and the implications are truly devastating. It affects every aspect of a child's life. See, many countries base citizenship on dissanguineous citizenship by blood. You inherit your parents' nationality. If a child is born in the U.S. and the U.S. doesn't recognize them as a citizen under this policy, and their parents' home countries don't automatically grant citizenship to kids born abroad, which is often the case, or involves complex processes, then these children effectively belong to no nation, no legal identity anywhere. They can't get a passport from any country, can't claim fundamental rights from any government. They'd be stuck in this perpetual legal limbo, unable to travel, work legally, fully integrate into any society, including the one they were born and raised in.
Can you give us some specific, detailed examples from our legal team's research? How hard would it actually be for parents from different countries to get citizenship for their U.S.-born kids if this order takes full effect? It sounds like it's not just filling out a form.
Oh, it's incredibly difficult, often impossible. The challenges are immense and vary by country, creating these awful dilemmas. Take parents from India. A huge number are H-1B skilled workers here. Citizenship by descent requires strict registration at an Indian consulate within 1 year of birth. Often needs in-person visits by both parents and the child, extensive documents. But many Indian H-1B workers are stuck in green card backlogs for over a decade. They often can't travel internationally without risking their green card application. So the logistical nightmare of traveling across the country to a consulate in New York or San Francisco with a newborn, all documents perfect within 1 year, often impossible. Miss the deadline. You have to seek special permission from India's Ministry of Home Affairs, a bureaucratic process that takes years, often fails. Without registration, these kids are stateless, can't claim Indian citizenship, no U.S. rights, caught between two systems denying them. For parents from China, it's even more restrictive, almost a dead end. Chinese citizenship generally requires a parent holds a hukou, their household registration. Most F1 students, H-1B workers give that up for U.S. visas. Plus, China strictly prohibits dual citizenship. Even if a child could claim Chinese citizenship, unlikely without hukou, the parents risk losing their U.S. status. Returning to China is impractical. These kids are left completely stateless, no path to Chinese citizenship, no U.S. recognition, a perilous legal limbo. In the case of Mexico, citizenship by descent also typically needs consular registration, often in person, parental IDs, birth certificates. But for millions of undocumented parents from Mexico here, the fear of detention, deportation is overwhelming. Visiting a consulate means interacting with authorities, risking exposure to U.S. immigration enforcement. Travel to Mexico is impossible without legal U.S. reentry papers, which they don't have. Without registration, the kids can't claim Mexican citizenship, stateless, vulnerable. And similarly for countries like El Salvador and Guatemala, consular registration, often in person, documentation needed. Undocumented parents face the exact same fears. They avoid any official contact, even their own consulates, to protect their fragile existence here. Risking deportation for themselves or other family members often outweighs registering the child's birth, tragically. So, without Salvadoran or Guatemalan citizenship, their U.S.-born children are left in this dire legal limbo no nation claims them.
Feeling lost in a maze of visa types and paperwork? Don't know where to turn? We've got your back. With clear answers and real help, we'll guide you every step of the way. Let's navigate it together. Your journey starts today.
Hello, you must be Clara. Welcome to the law office of Chris M. Ingram.
Finally, I found a law firm that will help me achieve my American dream.
At this law firm, you are important to us. That's why we will be with you every step of the way. So join us at the office of Chris M. Ingram.
That paints an incredibly stark, deeply unsettling picture. Life in the shadows. So what would life actually be like for these stateless children living in the U.S., growing up here without a recognized nationality? What opportunities, what basic necessities are denied, even if they went to school here their whole lives?
Our legal team's research points to a lifetime of systemic exclusion, profound marginalization. Now, it's important to note the 1982 Plyler v. Doe Supreme Court ruling guarantees K-12 education access for all kids, regardless of status, so they can go to school. But beyond that, opportunities just vanish for stateless children. They wouldn't be able to get fundamental documents most citizens take for granted. Passports, social security numbers, that alone is a massive, crippling barrier. Bars legal international travel, legitimate legal employment in almost all fields, getting a driver's license in most states, professional licenses, higher education, largely inaccessible. No federal financial aid without citizenship or eligible status. Though some states like California do offer limited in-state tuition benefits to undocumented students. Healthcare, mostly limited to emergency care in most states. Constant health insecurity. Although, again, California provides comprehensive medical to undocumented kids, so essentially, stateless children would grow up in the shadow world. Educated, maybe, but denied the identity, mobility, economic opportunity, full participation that defines American life. It's a life on the fringes, without recognition or security, constantly vulnerable, always on the outside looking in.
This brings us back to attorney Chris M. Ingram's powerful description. What does he say about this dismal predicament? What does it feel like for those affected?
Chris doesn't mince words. His description really drives home the human toll, the sense of injustice. He laments, and this is powerful, undocumented children can go to school, but depending on what state they live in, access to other opportunities, such as employment and travel, is not possible, but some limited health care might be available. All in all, it is a dismal predicament to find oneself. It feels almost punitive. His emphasis on punitive is really critical there. It highlights the sense that these children, through absolutely no fault of their own, are being punished. Punished for circumstances entirely beyond their control. Punished for being born in the wrong place at the wrong time, under these new restrictive rules. It feels unfairly targeted, perpetually disadvantaged for a status they never chose.
And how do these policies hit families directly, especially those mixed status families, some citizens, some potentially stateless? What are the burdens they're grappling with?
For families, the consequences are truly heart-wrenching. Immense emotional, logistical, psychological burdens. Parents on temporary visas, like those H-1B workers from India we talked about legally here, contributing massively, face the agony of raising stateless children in the country they're helping build. They're here by invitation, yet their kids, born here, could be denied the most basic belonging. Undocumented parents, often from Mexico, Central America, live in constant agonizing fear. Caught in an impossible bind, can't register their kids with the home consulate without risking deportation, tearing the family apart. Mixed status families where one child might be a citizen, born before the policy, and another stateless, they face incredibly fractured futures. deep divisions within the family, affecting everything from travel plans to future education, jobs, profound inequality in the same house. Our legal team's research shows community organizations reporting a staggering 35% increase in family counseling requests since 2018, as parents grapple with the unimaginable prospect of raising stateless children, the constant insecurity. This policy's threat isn't just legal or economic. It's a profound humanitarian crisis, tearing at America's moral fabric, its self-image as a land of opportunity.
Beyond the individual and family impact, our legal team's research also touches on broader economic and social consequences for the nation. What are the public and expert reactions to these proposals? How divided are opinions on something so fundamental?
Well, the proposal ignited fierce, highly partisan debate, highlights deep divisions. Expert legal opinions, especially constitutional scholars, civil liberties advocates largely unified in opposition. Citing the 14th Amendment, Wong Kim Ark, Omar Jadwat of the ACLU stated flatly, the president cannot strip people of their citizenship, challenging the legality of doing this via executive order. Erwin Chemerinsky, prominent scholar, added, the 14th Amendment is clear. If you are born in the United States, you are a citizen. Underscoring the view this is settled law. In terms of public opinion, our attorneys note a Pew Research Center survey found 49% of Americans oppose ending birthright citizenship. Substantial public resistance.
Is there any significant support for the proposal then? Or is it universally opposed?
No, definitely not universally opposed. There is significant support, mainly along partisan lines. That same Pew survey noted 25% of Republicans support ending birthright citizenship, reflects a significant partisan divide. A substantial portion of one party sees the current interpretation as problematic. Their arguments often center on national sovereignty, border control, the idea it incentivizes illegal immigration. They believe curtailing it is necessary for secure borders, national identity. So opinions are varied, with a strong group advocating for the policy shift.
What's fascinating here, and something our legal research really digs into, is how these immigration policies might ripple through the economy, particularly tech. What does our research tell us about the potential economic impact?
The economic implications are quite significant, yeah. And the tech sector is highly sensitive, vulnerable to these shifts. Silicon Valley, for example, relies heavily on H-1B skilled workers, mostly from India and China. Our attorneys found these individuals fuel something like 65% of Silicon Valley's workforce, driving innovation at Google, Apple, Microsoft, countless startups. The threat of their U.S.-born kids becoming stateless creates immense uncertainty, anxiety for these workers and families, and this has led to a measurable impact. A noticeable 15% drop in H-1B applications since 2018. Talented people are increasingly hesitant to move to a country where their children's future status is precarious. This means tech firms are struggling more to recruit and retain the global talent they absolutely need to stay competitive globally.
That sounds like a major hit to American industry, our innovation capacity. Are companies actively responding beyond just worrying? Are we seeing tangible consequences?
Indeed. It is a significant hit, and companies aren't just passively watching, they're actively responding. Our attorneys found major corporations like Microsoft have publicly voiced profound concerns. Microsoft specifically warned, and I quote, ending birthright citizenship would be a mistake, undermining our ability to attract global talent. This isn't just talk, it's about business consequences, strategic shifts. We are already seeing concrete evidence of companies relocating jobs, even R&D centers, to places like Canada. Canada offers more stable, clearer immigration pathways for skilled workers and their families. They actively market themselves as welcoming to tech talent. This direct consequence ultimately costs the U.S. significantly. Lost innovation, decreased economic growth, potential erosion of our standing as a global tech leader. It clearly shows immigration policy isn't just abstract law, it has profound direct economic effects on national competitiveness and future prosperity.
So what does all this mean for you, our listener, for the very idea of what it means to be an American citizen going forward? This deep dive into our legal team's research reveals a society really grappling with its own foundational principles, caught between history and these unprecedented policy shifts.
Yeah, if we connect this to the bigger picture, it raises several incredibly important questions. Questions that will shape our future. How might this evolving patchwork of citizenship laws, different rules depending on the state you're born in, the shifting sands of legal challenges, how will that evolve? Will this fragmented approach become the new, unsettling norm? Or will further legal challenges eventually unify the interpretation across the country? And what kind of precedent does that Supreme Court procedural ruling on injunctions set for future executive actions and challenges? It hints maybe at a future where executive power faces less immediate broad judicial pushback. This is a complex, highly dynamic space. It demands continued attention, critical thought from all of us. It's not just about abstract policy or legal frameworks. It's profoundly about human lives, family stability, and ultimately the very soul of a nation that has long prided itself on being a beacon of opportunity and inclusion.
Thank you so much for being with us today. Please leave us a like and comment if you can. Also, check us out on YouTube. Additionally, please share this podcast with your friends and family to help us spread the word. We would also like to thank attorney Chris Ingram and his dedicated team for researching and preparing this legal research for our presentation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughUSA.com and schedule an appointment. We'd love to hear from you and help you if we can. See you next time on Let's Talk U.S. Immigration. Bye for now.